Good evening, everyone. It gives me immense pleasure to welcome you all to today's program. I extend a warm welcome to, of course, our director and deputy director has gone to High Court. They have assured that they will certainly try and come before this conclude. So, of course, our senior mediators, trainers, and my dear friends. Of course, people who are appearing through video conferencing, your presence, whether it is in person or online, has made the occasion truly meaningful. It's my privilege, special privilege, to welcome our distinguished speaker for today's session, Madam Vaishali Hegde. I have I have had the pleasure of knowing her as a good friend, a learned trainer, mediator, and a respected professional whose knowledge, experience, and practical insight have benefited many. We are indeed fortunate to have her with us today to share her expertise. Madam, on behalf of everyone present, I extend a warm welcome to you and respectfully invite you to the dais. May ask Madam to share a bouquet or a flower pot. Yeah, yeah. This way or this way? Madam, we are honored by your gracious presence and look forward to your valuable address. I am confident that today's session will be both enriching and thoughtful, thought-provoking, and that each one of us will take away valuable learning from her presentation. On behalf of the organizing team, I once again extend a heartfelt welcome to everyone. Thank you for your presence, and I wish all a fruitful and engaging session. Thank you. Thank you.
Good evening to my mediation family. Thank you, Viju, for your very generous comments. It is indeed a pleasure and an honor to be addressing you all. It's such a learned lot. I had to do a lot of homework. And so even if you do get bored of the subject, please appreciate the hard work that has gone into it. uh, so I'd like to start by thanking the Board of Governors, High Court of Karnataka, the Director, Karnataka Mediation Centre, Deputy Director, Karnataka Mediation Centre, the Registrar Computers, Assistant Registrar General Dharwar and Kalburgi Bench, mediators, extended mediator family, mediators of Kalburgi and Dharwar, and mediators and staff of KMC. Thank you so much. I thank you all for making the time to be here today. Uh, uh, Rukmini was asking me a little earlier what it is that made me choose this subject, why, and how it was pertinent or relevant since we are, doing court annexed, mainly court annexed mediation as on date. Uh, and I'm so glad she asked me that question because the main reason why I chose this topic today was because three matters in the recent past, actually, in the past 6 months. I'm sure a lot of my other friends have also had this opportunity, which were and are in arbitration, were referred to me for mediation in the High Court. And honestly, I was a little flummoxed as to how to go about it because an honorable judge was, the arbitrator, was carrying out the arbitration. And thereafter, suddenly the matter was, sent for mediation with no note or profile as to what had happened and what instigated the entire change of ADR or an addition to the ADR. So I thought, as far as possible, we should not be found questioning as to when we get this opportunity. So it's better that, whatever little I have been able to gather in the past 3 weeks, where I got time to prepare this presentation to you, I share with my family. No? So the whole thing, of course, the topic today is integration of mediation and arbitration in India. The case laws are comparatively limited. You will please excuse me, but in spite of a lot of research, at least I could not find any specific case law which spoke about how arbitration or mediation were integrated, and therefore this judgment has come across. There may be, I'm sure there will be, but there is no reported judgment as far as I know. So the few judgments that I will be quoting will be from other courts, but it's okay. We are all here to learn. Now, to start with the topic, we all have heard of this term Med-Arb. I believe Mr. Shivkumar, late Mr. Shivkumar, did a short session on it thing. I remember, we all remember him very fondly. He was the one who introduced a lot of topics to us. Anyway, what is Med-Arb? So we will deal with what is Med-Arb. Med-Arb is an integrated system of dispute resolution wherein there is a combination of mediation followed by arbitration. Okay? Now, how does it work? Where there is a dispute between the parties. Now, we were talking earlier. We felt it is mainly in commercial matters that Med-Arb situation may come. But I have got a little bit of news in that also. There are even matrimonial matters that could be used. Hmm? Now, where there is a dispute between the parties, and there's a mutual agreement, there should be an agreement that the parties would go for mediation and have a try to settle the matter in mediation, and thereafter, at the first instance, however, if that were to fail, then they would thereafter immediately transition to arbitration to ensure that it is swiftly disposed of. See, finally, what is the entire idea of these alternative dispute resolution? The whole idea is to help, lessen the docket explosion that's happening. Let the parties find a solution to their problem. Of course, in arbitration, that's not what happens. But if it does, as I said, as is stated here, you try mediation. If mediation fails, then you progress to arbitration. It's not as easy as it sounds, but anyway, we will deal with it in the course of the evening. Now, in negotiation, this is a small illustration. As you see in negotiation, the content is basically just two people negotiating. We're not talking about negotiation in arbitration and negotiation in mediation. We are talking about in general negotiation. It's between two people. When it's in mediation, the neutral mediator is so loud. No? In mediation, a third party is involved. And so in arbitration, the two lawyers in black are there and the arbitrator. Whether it's 1, 3, it doesn't matter, but it's an arbitrator. In the process of negotiation, again, the involvement is only between two people. In mediation, during the process, there are three people involved. However, the arbitration is controlled by one person and one person alone. It's only the arbitrator. And hence, the outcome of a mediation, of a negotiation is again between two people. What they decide the outcome of the same. Mediation is again two people. The mediator does not decide. The mediator helps in the process. In arbitration, the one person, the arbitrator, just like in court, he will decide. So that is a brief outline as to how the three processes work. Now, what are the important factors? Is it too small? Other Niban Marvik, sir. I'm not very tech savvy. You know? Anyone's got my iMac? How do I make it full screen? You've got, no? How do I make it full screen? Important factors to consider in Med-Arb procedure is Who plays the role of the neutral facilitator or a mediator? And in case of failure to reach a settlement, who plays the role of an arbitrator? Okay. Is it the same person? Is it somebody else? Who is it? The next question to be thought of is the arbitration proceedings can be adopted even if there's a failure of the mediation process. Even if there's a failure of the settlement between the parties on all issues in mediation or just one issue. It can be partly mediated and partly arbitrated. So it could be one or all, depending on the facts and circumstances of the particular case. The next and most important point is consent and waiver mechanism, which are a must. This is to ensure, I will deal with it in detail as we go. This is to ensure that there are informational barriers which prevent any confidential information which is given in arbitration or in mediation from leaking and contaminating the next process, whether it is arbitration, whether it's Med-Arb or Arb-Med. So to see that there's no leakage of information, that is why we need this consent and waiver mechanism. I will take you all through it later. Now, brief description of Arb-Med An. What is Arb-Med An? Parties, see, as we were talking earlier, in these commercial mediations, very often there's an arbitration agreement. However, now it's because arbitration is proving to be very expensive and time consuming. Very often nowadays it is, even though there is a arbitration agreement, courts are sending it to mediation. Our very high court is sending it to mediation. So Arb-Med An. Now arbitration, Arb-Med An is when you first try out arbitration. Either you settle some of the issues or settle all of the issues, be it as it may, whatever the remaining issues, that is sent to mediation, or the parties decide that they will try mediation to sort it out. In case of the parties reaching a settlement, it is always open for them to go back to arbitration because finally they want a conclusion. They try all the methods. So if both arbitration was not successful initially or whatever it was, so they tried mediation and then they transitioned back to arbitration. Now I'll take you how it. Similarly to Med-Arb, as the name suggests, this is a hybrid dispute resolution process involving arbitration and mediation. How it works. So this is what is very important and extremely interesting actually. In the days to come, I think, I hope we'll be doing things like this. The parties initiate a complete arbitration proceeding wherein there is an exchange of pleadings, evidence is gathered, hearing, whether it's in phase or optional, that takes place. And following this, the arbitration proceedings is done, barring preparation and publication of the award. The arbitrator will do all this. He will your claims are taken, your evidence is recorded, everything is done, hearing is concluded. At that stage, you just before pronouncing the award, he will ask you, do you want to try mediation? Now, he knows which side he is going to rule. Okay? So therefore, perhaps in the interest of settling the dispute once and for all, he says, do you want to try mediation? The parties then proceed to go for mediation. Now, please understand the award is ready, but it is not pronounced. So, if they go for mediation, proceed to try and reach a settlement. With this background, that and knowledge that the arbitral award is ready. It is like the judgment of the High Court being ready, but the court says, go try mediation. And when they say that, obviously it means that one side is definitely going to lose. Obviously, in the court anyway, and in arbitration, there's no win-win situation. But there's a possibility, is what the court is trying to tell you, or here, of course, the arbitrator is trying to tell you. And the arbitral award is sealed and will be published only if the mediation were to fail and no settlement was to be arrived at. If the parties reach a settlement in mediation, then the mediator draws up a mediation settlement. And if the parties, however, fail to reach a settlement, then they are back in arbitration and the arbitral award will be published. Okay. So, and this will be binding on the parties like any other arbitral award. See, this is what I did not know. I honestly did not know that this happens. I thought parties choose mediation arbitration and they want, they run into arbitration. When they want, they come out and, try mediation. I didn't know that there is an award already ready and waiting. And in case of failure, that is when it is published. The important factors to be considered in Med-Arb procedure is the existence of an unpublished arbitral award. So there is pressure on the parties to find a solution in mediation. See, as long as there's no pressure, they will keep coming in, taking dates, you know how they behave, and we all will be waiting here. But when there is an arbitral award that is ready, and in the course of the arbitration, they also would have figured out which side the arbitrator is leaning. So there is that extra push to come to kind and try and resolve the issue. In that situation, the fear or uncertainty that the parties may have had of an arbitration proceedings if it were to take place after failure of reaching a mediation settlement. See, this is another positive, is what they say, that not only there's an arbitral award, so there is an incentive to try mediation. But however, there's always a confidence that if it fails, we don't have to go back to the entire procedure. The award is ready. It just has to be published. So that confidence is there with the party who's perhaps thinking of succeeding. Those who are in the balance, both will try to mediate a settlement. So this is the how it plays out. The parties would therefore have more reason to settle in a candid manner, as they can get a win-win situation instead of relying on the unpublished arbitral award, which could go against them. So that pressure is what would drive the parties in arbitration to opt for mediation, to try and settle the matter as amicably as possible. Now, the developments and takeaways of mediation, Med-Arb and Arb-Med An around the world. I will take you through 3 judgments. I think once I take you through 3 of them, you will kind of understand how they work in the, this Med-Arb works. Now, the parties of the dispute were involved in a construction dispute concerning substantial delay for whatever reason. Now, arbitration was carried on for 12 days. On the final day of the arbitration, the arbitrator asked the parties, would you want me to try mediation? Now, can you imagine? He has heard the matter, the arbitral award is ready. Then he gives them a last chance. Would you want, the arbitrator asked the parties, would it be open to him acting as a mediator and to put forward a settlement proposal under the cloak of a mediator? Now, why I found this interesting is the new Mediation Act, if you'll have gone through it, mediator proposal is contemplated. So please, we always keep saying, please think big. We are mediators today, but tomorrow, once the act comes in, all this will be useful. You will perhaps be given, if the entire act is, put into, play, then a mediator's proposal is contemplated. In the West, a mediator proposal is permissible. That is, they ask them, do you want me to give my proposal? Then it's only then they give the proposal. But here, very clearly, we have been trained to say, we don't propose, we don't hint, we don't suggest, we don't advise, we just listen. But that will change if the act comes into force in totality. Therefore, if parties are in arbitration and if the arbitrator, if they choose that the same arbitrator could be mediator, then it is always open for the mediator, if once the parties agree, to give a mediation settlement. You all would have heard on several occasions, the parties would have said, leave Tilsi, madam, leave Tilsi, we will agree. And we have to restrain ourselves, even though we want to tell them what they should be doing. But we kind of put the brake. But once the act comes into force, perhaps we'd have more freedom. Then, another interesting thing is the same person who acted as an arbitrator seeks the permission of the parties to act as mediator. See, the difference is, okay, here, like in the court, all the legal points and whatever facts that have been put in front of you. But as a mediator, he is going to know the internal stories. That we have to think whether that sounds fair or not. It's open for everyone to consider. We will discuss that. Then, parties provide written consent. This is why they give written consent to the mediator to act to the arbitrator to act as mediator as required under so and so act, that is New South Wales, that's as per their act. Okay, now they moved into the breakout room, where the arbitrator proposed that both parties drop their respective claims without them trying to achieve a win situation. A win situation would be only when one party wins. So, not to achieve a win situation. On the other hand, over the other, and instead stomach their own costs and settle the dispute on such basis and try a win-win situation instead. The parties anyway immediately rejected such a proposal. So, the hearing by the arbitrator was to continue, and the arbitral award, which was in the sealed cover, was pronounced. Crucially, they failed to sign the second consent. Please understand. Now, arbitrator, when he became mediator, he took one consent. Okay, can I be your mediator? Now, when from mediation I go back to arbitration, I have to take another consent. This is in their law, but if you see, I think it will be most practical even here. Because tomorrow, otherwise, this is the situation that will arise with the one I'm going to take you through. So, when he forgot to take the second consent to resume arbitration after mediation. So, several days later, the losing party, of course, asserted that they had never given a written consent and hence sought to resume the proceedings, saying that the arbitrator's mandate had been closed in the first instance. Then, back to court, Supreme Court of New South Wales, the court held that the arbitrator's mandate had been closed. And therefore, acting as a mediator, the court found that the arbitrator did act as a mediator by proposing a specific settlement or compromise. See, mandatory written consent, this is why it is necessary. Because express written consent given after the mediation to resume the arbitration, this cannot be implied by from a transcript or a people's silence. Waiver and estoppel. This came in the first thing. The court rejected the argument. Now look at what happened. The court rejected the argument of ICA on the ground that it had waived its rights, concluding that actual knowledge of non-compliance is required for a statutory waiver to operate, which the parties lacked. So, suppose I continue with the arbitration proceedings after the mediation and I don't raise the objection at that stage, then the question of waiver will come. Then I can plead that he waived his rights for me to continue as arbitrator, and therefore I proceeded to pass the arbitral award. Just look at it, how very subtle it is, but it can have far-reaching consequences. Now, the Court of Appeal in New South Wales dismissed the application for leave to appeal as incompetent. It ruled that section so-and-so, a Supreme Court decision regarding the termination of the arbitrator's mandate is final and subject to no further appeals. So once what the Court of Appeal said is that once one court holds that the mandate for arbitration had been terminated, the question of further appeal on that question does not arise. That, of course, each country will have its laws. Once our Mediation Act comes into force, perhaps all this is something that we'll have to debate about and think and see that it is incorporated. Therefore, from the above case, it is evident that the Arb-Med An structure can be used practically. However, there are procedural requirements that which have to be highlighted. Failure to sign a written consent of the arbitrator when the parties switch back from arbitration to mediation and from mediation to arbitration. Arbitrator, when the parties, such requirements are a necessity to ensure that the process is transparent, fair, and non-arbitrary in nature. Therefore, while we introduce the procedural complexities, it ensures that the process can functionally work. Now, please understand, in the new act, because we are not using it as of now, it states that after every mediation agreement, the mediator has to sign. So the moment we sign, we become accountable to what is written there. So please understand, it's not going to be like what is happening now, where we can write anything, miss out a few points, and leave it to the Honorable Court to take care of the lacuna. We will be held accountable. In fact, in all the district levels, they've already started asking the mediators to sign the agreements. So we will be held accountable. Therefore, it's very necessary to get their explicit consent before we shift from one to the other, as and when the time comes. Now, this is something that happened in China. It was between the husband and wife and Kane Holdings Company, wherein the husband and wife were to transfer their shares to the company, the holding company, for a certain amount. Now, Keen commenced arbitration in Xi'an Arbitration Commission in China to confirm the validity of the agreement. That is, the agreement was to transfer the share for X amount. That is what was the agreement. And while Zhao, that is the husband and wife pair, they said that no, they went back on the agreement and said, no, we were made to sign it because of, due to duress and misrepresentation. During the arbitration, the tribunal, that's the arbitration tribunal, suggested mediation. So therefore, the two mediators, two arbitrators, the main arbitrator and the second arbitrator, called the parties for dinner. Only one of the parties. And over dinner, they discussed a proposal. What is the proposal? That the company pays $350,000 and close the issue. Okay, they did not agree, and next day they went back to arbitration. Now, please understand very clearly, the dinner was with one party and two of the arbitrators acting as mediators. Now, Keane rejected the proposal, arbitration resumed. The final award, and in this particular case, the award was not yet ready. Unlike the other case where the award was ready, in this case, it was not yet ready. So, the final award was given, the final award was passed, which was in favor of Gao, the husband and wife. Obviously, Keane went up to court, and in court, these are the arguments that we may have to face if we are not careful. So this is just a head start. The judge refused to execute. He said, no, this execution is not possible on the ground of public policy, citing apparent bias of the arbitrator. Because one minute, morning he is arbitrator, evening over dinner he is mediator. So the court held that any fair-minded or informal observer would feel a palpable sense of unease and apprehend the risk of bias due to this unusual dinner meeting. Now, listen to what the Court of Appeals has done. The Court of Appeal overturned the lower court order and allowed the enforcement of the award. And look at the grounds. Waiver of the right to object. the court found that Kane was aware of the circumstances that might suggest bias, but chose to continue with the arbitration. And hence, because they did not object at that point of time, they ruled that you cannot go with the process and raise this ground as and when you so choose. Like in court also, the courts often tell us you cannot be sitting on the fence and then you see, when things are not going right, then you come to court. The court is going to say, what were you doing? So here, they, after the failure of the mediation, they continued with the arbitration with the same arbitrator who acted as mediator. And thereafter, when the award went against them, they challenged it. First court said there's apparent bias. The Court of Appeal said, since you have waived your right to object at the very first instance, it cannot be taken. And they said, you better enforce it. Now, the standard of apparent bias, the court clarified whether conduct gives rise to apparent bias depends on the local circumstances. Look at what is happening. A local circumstances where the mediation occurred. Since this was a case in mainland China, there I believe it is very common for people to meet over dinner and discuss settlements. So, as the Court of Appeal had already refused to set aside the award and determined that the dinner meeting was acceptable. Can you imagine if we do it here? Dinner meeting was acceptable under local practice, and the Hong Kong court gave this decision due weight. Public policy threshold. The Court of Appeal emphasized that the enforcement should only be refused if it is contrary to the fundamental conception of morality and justice of Hong Kong. A very high threshold was not met here. Then Arb-Med-Arb structure resulted in the arbitral award due to the failure of the mediation to reach a settlement. However, we see that from the offer of mediation compared to the arbitral award, it was a win-win situation that they have got in mediation. Unfortunately, because they decided to go back to arbitration, it was one party winning and the other party losing. But I was just thinking when I was going through this, if anyone had to do that here, I think it would create I think it is an out of something that cannot be conceived here. And personally, as a litigant, I don't think I want my arbitrator being my mediator. And tomorrow, my mediator coming and passing an award, it is a little too far-fetched for me to think. And certainly not in our condition. And even if we have a masala dosa together, tomorrow there'll be, I don't think we can do that. In the last of the three cases that I found, there was a conflict regarding payment, and one party said $3,500 dollars, which was then referred to adjudication. The judge, a retired judge was appointed as an arbitrator. During the meeting, the parties reached a provisional settlement on the gross valuation. But, however, there was a 3% discount, perhaps like a 3% interest that they were not agreeing upon. So that only that part of the dispute was referred for mediation. In mediation, a different proposal was put forth by the same arbitrator, and it was not agreed upon. However, and as he says, it involved a lot of shuttling between the parties, private session, focusing. All this we do regularly in mediation. But can you imagine the arbitrator doing that? While they reach a tentative figure, whatever it is, that doesn't matter. However, negotiations failed and the matter went back to arbitration. Arbitration finally, an award was passed, and once it went back to arbitration, one of the parties asked for a summary judgment. That was refused, and a final judgment was passed. Anyway, they went to court. In court, very clearly, the court refused to grant a summary thing, saying that there was an apparent bias. So you see, from country to country, how it changes, we'll have to develop our own rules. Okay, so we need to keep this in mind when we get the Mediation Act gets into, practice or force. The vital test, the judge held that the objective test for bias is whether circumstances would have led a fair and informed observer to conclude that there was a real possibility or danger that the tribunal was biased. And I think they most certainly would, at least I, as a normal human being, will definitely think there is an element of bias. Then compromised impartiality. The court found that because the adjudicator was a privy without prejudice and confidential information had been given to him during the private mediation session, which was material to the issues that he decided later, his impartiality was compromised. Okay. Outcome, the adjudicator's decision was held to be unenforceable because it had affected the apparent bias. And however, the court did order a conditional interim payment of whatever. That does not matter. So this is one of the main drawbacks of this entire process. Because wherein if periodically, procedurally, the system is not watertight, the chances of this accusation of bias and favoritism or, the procedure being tainted is always possible. However, as it is seen, the proposal from the mediation was beneficial to both sides. Had they agreed in the mediation, of course, it is always a win-win situation. But I was just thinking, why not sort all this out by just having a different person to mediate and arbitrate? It didn't make any sense to me why the same person was doing both. Huh? Once you said like what's happening in our high court from the arbitration center, after it reaches a particular point, that's when the honorable arbitrator sends it to the high court and says refer the matter to mediation. Why? The parties know what has gone on and how the scales are tilted, and that's when a neutral mediator starts from afresh. Why should I be privy to whatever happened there? And I found that a little strange. In order to understand the functioning of Med-Arb and Arb-Med-Arb in India, it is necessary to grasp the four main legislations that are in play. Arbitration Act, the Civil Procedure Act of 1908, Commercial Courts Act, the amended one, 2015, and the Mediation Act, not yet notified after 3 years, therefore not in force as on date. The Arbitration Act provides for procedural rules for conducting arbitration in India. Importantly, from a cross jurisdiction standpoint of view, it provides for the recognition of both the New York Convention and the Geneva Convention, therefore allowing and recognizing a majority of arbitral awards that are passed. Yeah. However, and the CPC through Section 89 provides for out-of-court settlements, disputes. You are all aware of it. Arbitration, mediation, lok adalat. The benefit of this provision is so that it promotes the courts to try for an appropriate ADR mechanism as the first solution before going to litigation or the adjudicatory process. Section 12A of the Commercial Court Act makes it mandatory for the parties to go for pre-litigation mediation before filing of a suit. This is another meaningful method to ensure the reduction of litigation and a fruitful settlement of disputes. And lastly, of course, the Mediation Act, though not completely in force, is crucial for making mediation a mainstream ADR mechanism as well as making it more accessible in different types of dispute resolution. It is also crucial for improving the procedural aspects for execution of a mediated settlement. Now, most of you all would have been thinking that this Arb-Med An, Med-Arb, Arb-Med could be used only in commercial disputes. Out of the 3 matters that were referred to me, 2 were matrimonial. As I say very often, now matrimonial matters are becoming more commercial than the commercial matters themselves. In fact, I also make suggestion that matrimonial matters can be sent to the commercial court because we start mediation with how many crores, so we might as well start there. Anyway, be it as it may, why I'll tell you. The matrimonial matter was regarding the husband, wife, children. However, she had shares in the company. She was a director in some company. How much she would get for that, and whether she was a director, sleeping director, standing director, all those sort of things. that part of it was sent to arbitration. You will not believe that divorce has gone through the matters regarding all their shares, they are still going on in the High Court because arbitration award was not given effective. They came Section 34, they're still going on in the High Court. Huh? Yes, and yeah, I don't understand that being director of companies. So, I happen to be the advocate in one of the cases, but no, nowadays it's so common. Say Shiv Kumar is nodding, Geeta's nodding. She knows these kind of clients. So therefore, even in matrimonial matters, it can be part of it can be mediated. The rest of it can be left for arbitration. Okay, so it does not have to be only a commercial dispute in the sense of a joint development agreement or a contract. All these matters also can be referred to mediation. Yeah, these sort of issues are there. Shares, directorship, all this. Yes, yes, yes. Now, okay, where India is compared to the rest of the world in this aspect. In India, Arb-Med An structure is one which has been facilitated through Section 30 of the Arbitration Act. Section 30 provides for settlement wherein the tribunal can encourage the parties to go for a settlement through mediation. However, the difference between a standardized format of Arb-Med An through in India in the current form is that, now please hear this. You all can, if you all are doing private mediations, or if you all, this sort of case comes to you all, where part of the dispute is there before the arbitrator, the other part of it is sent for mediation. Now see what happens. Now, India in the current format is, in India, if a settlement is reached by the parties during arbitration, the settlement is recorded as a consent arbitral award. Whereas in other jurisdictions, it is recognized as a mediated award. Why is that? Because there's no act in play. Once the act comes into force, if the settlement is arrived at mediation, we do not have to send it back to the arbitration center and make it a consent arbitral award. We can just register it with the council that is supposed envisaged under the act. But just look at it, we are still remaining backward because this act is not coming into force. It has been in the book for the past 3 years, and God knows whether it will be consigned to history without ever seeing the day of the light of day. Now, this changes the execution process completely. Once it's an arbitral award, there's an appeal, and most importantly, because it's an arbitral award in India, Section 34 for setting aside can be used. Then what is the point of a consent arbitral award? No, that's a see, you can file it. Then the court will have to say, whatever it is, let me entertain. Then the court will say, because it's consent, just like they said in that Supreme Court matter, where recently a mediation agreement was sought to be challenged. The Honorable Supreme Court said that, see, you have given consent, you cannot rescind from it. Same way. But the fact is, you can file it. And the process, again, you're acting to docket explosion, adding some more cases. Now, Indian courts are also pro enforcement of such consent awards. The Delhi High Court in so and so 2023 SEC Online Delhi, the court had followed a pro arbitration process by rejecting the contention that a foreign consent arbitral award could not be executed in India. So this was an arbitral award, arbitration mediation award, which was reached in arbitration abroad, but was sought to be challenged by one of the parties before the Delhi High Court. The Delhi High Court said, merely because it is an award made in a foreign land, because it is consent, we cannot say that it is thing. Therefore, that strengthened the foreign award executions in India. So I think you should take this judgment down. At some point of time, you may want to read it. It's, I think quite interesting. As seen, that Arb-Med An is favored over Med-Arb. Why? because the introduction of strict timelines are required for the completion of arbitration under under the 2015 amendment, Section 29A of the Arbitration Act. Even though there exists a non-neutrality in India, Arb-Med-Arb stature, as the arbitrator typically plays the role of the mediator as well, unlike in Singapore. While there's a separate mediator, this is favored because of its efficiency over a neutral Med-Arb structure. I am not totally convinced about this. This says that the same arbitrator acts as mediator. See, we have to be very careful. This is what will happen once the new act comes into force. The arbitrator will be conducting the process. Now he knows he's reached the end of it. At that stage, he will ask permission whether I can give you a mediator's proposal because it's permitted under the new act. So that they say, okay, we don't mind you acting as a mediator. They'll give their consent, and then he will give the mediator's proposal. And suppose the mediator's proposal is not acceptable to the parties, he will come back and act as arbitrator. So how far this is going to work? If it is only a proposal, maybe it is okay. But if it is a process, I don't think it sounds very, neutral, or I think that gives us food for thought. Then the Indian Institute of Arbitration and Mediation has drafted mediation rules, which are the closest to the official. It's not statutory, but closest to the official Arb-Med-Arb stature, similar to that of Singapore, which is in India. One of the important provisions in the theoretical rules is that the mediation settlement report will be sent to the arbitrator. And in case there are any points which are not yet mediated, the same can be dealt with in arbitration. So half arbitration, then mediation of some points. The remaining points will be dealt with by law, as per law, by the arbitrator. Then this incorporation of one or more facets of the Singapore style of Arb-Med-Arb structure, which is a portion of the dispute, is settled through mediation and the rest through arbitration, and vice versa. Therefore, it is evident that India is moving in the direction of and developing and incorporating Med-Arb and Arb-Med-Arb as a formal, institutional, and statutory structure. Yes, sir. My.
Hey, yes.
There are two principles of natural justice. One is to hear the other side. The other is that justice should be done, seem to have been done.
That is the
Okay.
book, sir.
No. The basic principles of jurisprudence is justice should not only be done, it should have been seem to have been done. Therefore, if the arbitrator acts as a mediator, that becomes a bias because it does not seem to be.
I
How
totally,
it is done.
I totally,
That is a basic principle. Let us say we can distinguish and find out how to separate the two.
no, I totally agree with you, sir. I find that extremely strange that the mediator acts as an arbitrator and the arbitrator acts as mediator. Even I think anyway, luckily, I mean, here they did it in Delhi. Therefore, I think only and so far as giving a mediator proposal, only one proposal, maybe okay. But carrying on a total and complete mediation process, I think I'm in agreement with you, sir. It sounds, yes, this is only in China and Australia. Uh, I'm sure it is because unheard of that the same person does both. Hmm? When mediation fails, I'll take all the questions and answer to the best of my limited knowledge at the end of the session so that I don't keep you all waiting. When mediation fails, in Med-Arb, who selects the arbitrator? Mediator allows a quick continuance and efficiency. However, major issue is the possible contamination of the arbitration due to the mediator cum arbitrator having confidential information about the parties. Now, third point is third party allows for arbitration to occur normally without the influence of a mediation process. However, the process to choose the arbitrator, fee structure, agreement between the parties is something that we'll have to develop in time to come as and when the Mediation Act comes into force. Or when you're doing it very clearly, the arbitration center is doing the arbitration and it's sent to the mediation center to settle the remaining parts of the dispute. That's what has happened in the 2-3 cases that have been referred. In case of mediation settlement is reached, what is the enforceability of a private mediated settlement agreement? As on today, as the Mediation Act has not come into force, the process of enforcement would be the same as any other private agreement. You will have to make it a contract, or if it arbitration process have been initiated, send it there, make it a consent arbitral award. With the enforcement through contract law, it will follow the ordinary process of going to court for enforcement, which then brings the issue of challenging the contract. Okay, so we are back to court. Then what is ADR doing? So then the entire process is diluted. The civil suit, decision to the said suit, appeal process, all that leads to a theoretical failure of the mediation settlement and the Med-Arb process. The case of Arb-Med An, what is the immediate issue can be spotted procedurally. The glaring issue is that arbitration takes place first. In fact, I think perhaps in the present situation that we are in, Arb-Med An would be the best because you are in arbitration. Whatever you cannot settle, you go to mediation, and a mediated agreement can be sent back to arbitration, and a consent arbitral award be forthcoming. If it is mediation and arbitration, if it is settled in mediation, private mediation, let us say, we're not a court annex, then again all this process of going to court, filing, and then challenging the very contract itself will come into play. So then the entire purpose of an alternative dispute resolution fails. So I think we need to force the government to think and as far as possible, change the definition of mediator first and thereafter enforce the Mediation Act of 2023. No, mediator. The definition of mediator has to change. Uh, the glaring issue of arbitration takes place first. Okay, that we've done. The benefit of the mediation, low cost, advocates not necessary, quicker, parties having more say, are all subdued because arbitration takes place first. The fact that it exists in a sealed cover, that is when the arbitration is over and the arbitral award is ready, may in disputes where it is apparent that one party is stronger than the other, obviously then mediation they're not going to agree, lead to the stronger party refusing to participate in the settlement of mediation with the belief that the arbitral award will go in his or her favor. Who will be the arbitrator? I'll just take 5 minutes more. Arbitrator or mediator in case of an Arb-Med structure. In the case of Singapore, there exist two bodies, SIAC and CMAC. That is Singapore International Arbitration Centre, Singapore International Mediation Center. So when arbitration takes place, then they appoint an arbitrator from SIAC, and then when it goes to mediation, they appoint a person from CMAC. We also in Bangalore have an arbitration center and a mediation center. So we are very close to Singapore in this aspect. So in India, however, we come back to the moot point. Without the Mediation Act coming into force, there still exists no central mediation center. Therefore, causing the issue of lack of separation of a neutral third party. While parties can choose to lead the issues challenging the validity of choice of mediator at a later stage. In case of Arb-Med thing, what happens when the arbitral award is given? Enforceability, as usual, is a big issue. as of now. Existence of section 34 and 37, as you know, has been the bane of arbitration. Appeal revision SLP, and the whole concept of the whole concept of arbitration is losing its meaning. What needs to change in India to adopt Med-Arb and Arb-Med? First and foremost step, the Mediation Act has to be enforced, has to come into play. The establishment of the Mediation Council, as you know, under the Mediation Act of 2023, there is a centralized mediation council. The mediation council will then have state level mediation centers, and that's how you, like any sale deed, you can go register your mediation agreement. So this will help in promoting mediation and, more importantly, making it more formalized and standardized form of ADR, thereby allowing international jurisdiction in mediation. Will allow enhanced enforcement of the procedure, sections 27 and 28. One of the important changes from the current system is the authenticated mediation settlement. That is, it will be registered and will have the same recognition as a decree passed in court, and therefore can be executed without delay. The next important thing is, for it to be successful, India has to adopt the international rules and procedures. If you want to be a part of internet, see, a couple of us have done training. We have done this training wherein now they told us you'll be called for international mediation. You'll be called to Singapore. We all have very nice looking certificates. Okay. So we believe that next morning we were catching the flight to Singapore. It is now 5 years. We have not seen the S of Singapore still. Because why? India is not a part of is not a signatory. It's not a signatory to the agreement. I cannot understand. If you want to be a part of the whole, the world order, we need to move. So enforcement of a mediated agreement settlement and arbitral award in India, there must be adoption, amendments to the system as it prevails now. So therefore, and which reduces appeals. The purpose of the same is to ensure that ADR actually reaches the grassroots level and the purpose for which it is made. Section 34, 37 of the Arbitral Act needs a relook. And last of all, the Mediation Act of 2023 although adopts the Singapore Convention in mediation, India as a state has not ratified it. It leaves a huge gap with respect to international mediations. Without ratifying the Singapore Convention, any foreign mediation settlement that is reached between parties cannot be enforceable in India, therefore leading to the complete breakdown of international mediations in India, which follows the Singapore Convention route. Therefore, I think I've made it on time, 5:30. Thank you so much for your I'm willing to take questions if there are any. Yes, please. Bye.
Any questions?
Bye.
Madam, can you hear me, ma'am? Can you hear me? Can you hear me?
Yeah.
Ma'am, we already have a Arbitration and Mediation Act, because it
Yes.
says that Arbitration and Conciliation Act.
Yes.
Conciliation, Chapter 3 of the arbitration itself is basically a mediation where we can go and do conciliation also. Because what happens is, when we submit to an agreement for arbitration in any of the act, we agree for Arbitration and Conciliation Act 1996. It is and it's not or. So we submit to both arbitration and conciliation, which is a part of the same act. Conciliation is nothing but mediation in another way, where parties agree that I will have a person who will be counseling or doing the conciliation.
Maintain silence, please.
So this mediation, this arbitration and conciliation is a part of it, but a conciliation nobody uses. But we are now terming it as arbitration Med-Arb.
True.
But it is conciliation and arbitration. If it is taken, what will be the difference?
Now, I am asking you, in conciliation, just in the process of conciliation, let's not talk about the industrial dispute under the disagreement. Can an agreement be reached?
It can
Which
be
is possible.
it says, as per the act, it says yes, if both the parties submit in writing that we are ready for conciliation, and we submit to Arbitration Conciliation Act 1996. We agree that, and then if conciliation agreement is drawn, that will be acceptable under the Arbitration Conciliation Award will pass. Yeah, arbitration. So that's why it's an interplay between arbitration conciliation.
True.
Same way as we are talking about arbitration mediation.
Yes.
Here also the arbitrator in the end of the day says go to conciliation, mediation, and come back to me. Or you because award he will be passing.
Now,
And one more last question is whether the fees will be paid back because initially itself arbitrator will take the money.
no, hopefully there will be separate fees for mediation and arbitration.
Because both the
Yes.
parties pay the money. In
That-
arbitration, both of them the money is split and it is taken in advance.
We'll keep that in mind when we give suggestions.
Because
For
you
the-
pay the money, we pay the money in advance.
Yes.
And
Yes. Thank you, sir. That is extremely important. Now, sir, one minute.
Please listen.
Sir,
Maintain silence.
now, if you go through this act, they have practically done away with conciliation altogether.
yes, all right. That's what I'm saying.
Altogether.
But always when I submit to the agreement, it's an agreement under the agreement, that is an arbitration
Yeah.
agreement, I agree under Arbitration and Conciliation Act 1996. I don't say Arbitration Act. I say conciliation is also part of it.
Now, I am wondering, once the Mediation Act comes into force, if it does,
Yes.
then what is the role of conciliation?
Conciliation has to be
Conciliation will
amended.
go.
It has to be amended. That's
will
what
go.
the conciliation is never done.
Yes,
Only thing. It is never
Exactly.
utilized. Chapter 3 is never utilized.
correct.
That is the only thing.
Yes,
Thank you.
absolutely. Yes, Shivkumar, anything? So many lines on your forehead. Huh? Any questions, sir?
No. Many of the aspects are covered in the Mediation Act. Many of the doubts that were raised are already covered in the Mediation Act.
Correct. I'm hoping that the message goes through that we want it enforced, but only after the definition is. Any other questions? No? Then thank you. We will wind up for today. Sir? Huh? Is that him? Ah. I thank who wants? Oh, there are. Oh, sorry. Kalburgi and Dharwad branch. Any questions? No? Any a mediator family from Kalburgi and Dharwad. Any questions? All right. I think we'll wind up. Thank you. I thank the Board of Governors, the Director, Karnataka Mediation Centre, the Deputy Director, Karnataka Mediation Centre, the Registrar Computers, the Assistant Registrar General Dharwad and Kalburgi Bench, the mediators of Kalburgi and Dharwad, the mediators and staff of KMC for bearing with me and for organizing this evening. Thank you. They told me to say thanks.
I think Vaishali's done me a favor. She's done the vote of thanks also. So thank you very much. Vaishali, that was a wonderful session. It was a different kind of a subject.
Right.
So, I mean, at least it makes all of us think about something different and do research on it. Thank you so much. You thank the rest of the people. So, no, you thank the rest of the people. I don't have to do it again.
Thank you. Thank you. Thank you. Thank you. Thank you. Thank you, Babaji. Divorce is over. The sales companies. Yeah.